Hello, this is Alexander Cross with Law Offices of Cross & Associates. If you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross & Associates. So we received an interesting inquiry here on our YouTube channel. Let's see, this has to do with somebody who was arrested for changing labels to items in a store. Let's see, a month ago I was arrested for changing the price labels to clothing at a store. The problem is that in 2005 and 2014, I was arrested for taking items from a shop without paying. Well, first, let's get into the whole 2005 and 2014 petty theft cases that you may have had. So I'm assuming you were convicted back in 2005 for the petty theft, and then you picked up another case in 2014. Now, the 2005 case would have been a prior for that 2014 case, since less than 10 years passed between the two cases. Now, back in 2014, the laws were a little bit different regarding petty theft. If you had a petty theft the prior, your brand new petty theft, as long as it was within 10 years, would generally speaking be filed as a felony. So you could have been looking at a felony petty theft even if the value of what you had taken was less than $950. So it's possible that your 2014 prior could be a felony, just based on the fact that before 2014, if you had gotten a prior petty theft within 10 years, your new case would be filed as a felony automatically, regardless of value. However, now in the year 2020, that's not quite the case. You picked up a new case, which would essentially be classified as petty theft, although depending on how sophisticated your technique was for changing store prices, well, they could even file a burglary if they could show that you had the plan to do it before entering the store. But assuming it's not classified as a burglary, that 2014 felony will still be priorable against you, and that will definitely affect you. In a situation like this, it'd probably be a good idea to talk to the DA to see if there's a way that you could enter some kind of rehabilitation program, because there are many people out there who just have this propensity to steal, and sometimes they can't contain themselves. But barring a program, what's going to be necessary to do in a situation like this is to suspend the criminal proceedings and essentially cut a deal with the DA's office to avoid county jail. Generally speaking, as long as you are charged with a misdemeanor, you should expect to get maybe something like community service or sheriff's work, some fines, fees, probation. But be aware that stealing is a crime of moral turpitude, which means that if you're not a U.S. citizen, this is something that could potentially result in deportation, exclusion from the United States, and denial of naturalization. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross & Associates. But if you've been accused of a crime and need representation in court, give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing a security guard from school who took a student's cell phone. See you on our next video.